Good morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime Live. This is where we cover some of the most interesting live trials in the country today. And today, we have two live trials for you. That's right, two live trials, and I want to start off with the major one, the one that's been on break last week, the one we've been patiently waiting for, the Tex McIver case out of Atlanta. This prominent attorney who is on trial for shooting and killing his wife, Diane McIver, by shooting her from the backseat of a moving car. The prosecution claims that this was an intentional shooting, an intentional killing, while the defense is saying it was all a tragic accident. The gun misfired. He took out the gun when they were driving in the car, him, his wife, and Danny Jo Carter, who was a friend of the couple. She was driving, and it was just a terrible accident gone wrong. The prosecution is really trying to say that Mr. McIver killed his wife for a number of reasons, but most importantly, for financial gain, that he had a lot to gain with her dead as opposed to being alive. Now, right now, I am looking at a live feed in the courtroom. As soon as trial starts, we are going to go right into it. We do not want you to miss anything. We are in day 15 of this case, ladies and gentlemen. The state is going to continue its case, and you do not want to miss anything. But that is not the only case we're covering here on Law and Crime Live. We are also covering the William Knight case out of Ohio. Now, if this case should start before the McIver case, we'll go right into the courtroom, although our focus today will be the McIver case. But in the William Knight case, this man is charged with shooting and killing an unarmed man named Keith Johnson after what was an attempt to recover a stolen dirt bike. And what we saw last week on Friday was the testimony of Mr. Knight's son-in-law as well as his daughter, so Curtis Gill and Michelle Gill. And we saw the testimony of the defendant himself. He took the stand trying to explain why he shot this man, Keith Johnson, over a dirt bike. And if what Mr. Knight is claiming here is self-defense, he felt that at this moment, during this altercation, that Mr. Johnson presented a danger to his family and that this was a credible threat, and he felt the need to take out his gun and shoot Mr. Johnson. However, when he was on the stand and when Curtis Gill and Michelle Gill were on the stand, I got to tell you, it is not entirely clear if this was a valid case of self-defense. We'll talk about that in a little bit, but I really, really want to focus right now on the Tex McIver case because it's been off for a week and there's a lot to digest. So before we go live in either of these courtrooms, and I'm looking at the court feeds right now, I want to bring in my very special guest, criminal defense attorney Jonna Spilbor. Jonna, good to see you. Good to see you as always, Jesse. Let's talk about the McIver case. So the last thing that happened was that on Friday, this was the day 14 of the case, a week ago, an argument ensued outside the presence of the jury concerning whether prosecutors could present evidence from an emergency room doctor that McIver talked down to him in a racial manner when doctors approached him to notify that McIver's wife was dead. Now, the judge ruled that this evidence was actually more probative than prejudicial and that it could come in, but that he would not allow prosecutors to hype it or draw a lot of attention to it. What does this mean?
I have no idea. First of all, excuse me, what does it mean for someone to talk to another person in a, quote, racial manner? We don't know whether that means he used a racial slur. We don't know in what context that happened. We don't know exactly what he said yet. We don't know why he said it, number one. Number two, what is the probative value of that? If you are trying to prove, the prosecution is trying to prove that this was no accident, that this was intentional, what does, let's say he was very rude, right, to the hospital attendant. What does that prove in connection with, was this an accident or not?
Couldn't the argument be that if that he took out his gun, or let me rephrase, that he had his wife hand him the gun in the backseat of the car because there was a Black Lives Matter sort of people around, which is, again, the common theme that you keep hearing. Right. Did he mention that this was a Black Lives movement, or was it not? If you can try to show that Mr. McIver is a racist, and you could try to say he took his gun out for that reason, is that what it's about? But even if that's true, how does that relate to whether or not he wanted to kill his wife intentionally?
Well, hang on a second. Even if that's true, how does it help the prosecution? It almost would more help the defense. If the defense is going to claim, look, the only reason that he had his now deceased wife hand him his gun is because they were in a bad neighborhood, there were protests going on, and he was in fear for their lives. Right. Then if he is a racist, and I hope he's not, that almost fits that bill better, not for the prosecution. So it's very strange, if that's the case, that the prosecution would be bringing this up. Now let's turn to, though, when a judge says, I'm going to let in evidence XYZ, but I don't really want you to hype it up or talk about it. Does that mean you can't bring it up in your closing argument? Does that mean, what does that mean? If the jurors have a question about it, is the judge going to say, I'm not going to answer that for you?
My confusion is it's not like this witness that'll be brought on will talk about a gamut of issues, and that might just be one of the statements that's made. If this person is being brought on for that specific fact, how do you not draw attention to it?
Exactly, because it's such a strange fact. So I think the judge here probably made the wrong call, but as so much of the evidence in the prosecution's case has proven thus far, I still think the prosecution has a long way to go to get to beyond a reasonable doubt. They seem to continually try to stick these square pegs in round holes when it comes to proving motive, especially motive in this case, which isn't an element, but it's going to explain to the jury if he did intentionally kill his wife, why he did it. And the prosecution is still falling flat. Now, we have a whole week gap, Jesse, that those jurors got to go home, lounge around, maybe read up on the internet what's going on.
I hope they didn't.
They're not supposed to, but was somebody babysitting them, policing them? You know that the answer is no.
You mentioned that we've been off for a week. Well, we haven't been off for a week, but McIver case has been off for a week. So what I want to do right now for all of our viewers to get reacclimated to this case, I want to play right now. This is the testimony of Danny Jo Carter. She is the woman that was in the car. She was the driver. She was the only eyewitness to this shooting. So I want to play some of her testimony for you. And when we come back, hopefully we have a live feed in the McIver courtroom. Let's go.
Like it's locked. And I looked at mine and my door lock was up. So I hit the button and locked the doors and I said, no, now they're locked. And I think that's the last thing that she said.
Before?
I heard a big boom and I didn't know what it was. I thought there was an explosion somewhere. And my head turned to the right, and I looked out the window and wondered where there was an explosion or if somebody behind us was getting ready to hit us or something had happened behind us. I did not realize that it was a gunshot right away.
How did it sound?
It was loud.
And so can you tell the jurors what happened next?
Diane turned around, like, she turned around this way. She flung around and she says, Tex, what did you do?
Tex, what did you do?
Mm-hmm.
And did he say anything?
He said the gun discharged.
And so, what did you do when Diane McIver turned around to look?
When she turned around, I turned around and realized seconds. This was all happening in seconds. And I saw a puff of smoke and I could see his hands. And I could see the top of the gun, I could see part of the gun, his hands, and some of the bag.
Okay.
And his hand was moving like this.
Show the jurors again what you saw.
Something like this.
That's Danny Jo Carter, the driver of the car in the Tex McIver case. She was driving the car when Tex McIver shot his wife from the back passenger seat, the only eyewitness to the crime, trying to explain what she saw and heard. Now, before we get into the live trial, and I'm looking at the feed in that Atlanta courtroom, as soon as we have it, we'll make sure to go to it. There's so much to digest in this case, I'm not even sure where to begin. But, Jonna, do want to let our viewers know, one of the reasons there's a delay right now, Juror 61, who's been consistently late throughout this whole process, is also late today, but we know that she's now in the building. How is a juror consistently late after being admonished by the judge?
You know, I don't know. Maybe they feel like, what's the worst that can happen? You kick me off this jury? Great. I don't have to sit here for another week. I don't know.
That's a good point. Okay, before we left off in the McIver case, we saw the testimony of Darren Smith, Detective APB of the Homicide Division, brought on by the state.
Right.
What we learned was that he did not thoroughly investigate the matter as much as the state would have liked. He didn't ask so many poignant questions. He didn't even ask how the gun went off. And he said, look, the trigger went cold, that I know. Whether it was a single
Obviously.
action or double action didn't make any difference to me. This is the lead detective in the case,
right.
The murder case, where the way that the gun was set, whether it was single action or double action, will let you know how many pounds of pressure were required, whether it was an accident or not. We kept seeing these comments from him that he didn't thoroughly do the proper tests. He didn't ask follow-up questions.
Right.
How damaging is that for the state?
I think it's extremely damaging. It's clear that this detective really kind of made up his mind in the beginning that this was indeed an accident, and he didn't bother to probe anywhere else. So it's going to help the defense in that it's beyond creating a reasonable doubt just by the fact that he didn't do what maybe he should have done. And the prosecution is doing a great job of pointing that out. But it's going to backfire on the prosecution. It's going to help the defense.
Yeah, you have to see the state calling so many witnesses that have not helped their case.
Yeah.
You try to see, now again, this is a live feed into the courtroom. This is DA Clint Rucker trying to get the answers from so many witnesses that he wanted to get, including Jonna. He kept trying to ask people that knew the McIvers, well, did they have fights? Was Diane McIver overly abusive, physically, verbally abusive to Tex McIver? And not every witness was, no, they had common fights, they had a normal marriage. How many times do you see this where the state is actually helping the defense's case?
It doesn't happen often, but when it happens, it really happens, and it's happening in this case. I'm calling the driver the main witness here, right? Danny Jo, what's her last name?
Carter.
Danny Jo Carter is the main witness here, only because she's the only eyewitness to the actual event. Although she saw a puff of smoke, she didn't actually see him pull the trigger. But when you look at her and her testimony, if the state's theory is to be true, that he planned and plotted this murder because he was financially motivated, do you really choose to kill your wife in the presence of a witness who's 2 feet away? I say probably not. So that's the first hurdle that the jurors have to get over, in my opinion.
He is charged not just with murder, but also 3 counts of influencing witnesses, including Danny Jo Carter, trying to tell her what she should say to the police and what she shouldn't say to the police. Initially, he tried to have her say, look, don't even say that you were there. Don't even say you were the driver. Now, he would say, and what the defense has said, I don't want you getting involved in this whole mess.
Right.
Do you see a situation where he might be found not guilty of murder, but found guilty of the 3 influencing witnesses charges?
Absolutely. And that would still be a win on behalf of the defense, because if he's not convicted of the top count, obviously he's got a chance to not spend the rest of his life behind bars. And I can also see, not that this excuses his behavior, but he's a lawyer, and he was a lawyer for a long time. And excuse me, I could see him not intending to influence a witness, but just putting his lawyer hat on and just trying to kind of handle this himself. Doesn't excuse it. Probably will be found guilty of those lesser counts, but that would still be a win.
Maybe, unless they give him, do you think they'll have a lesser included? In other words, he might, jury, if you don't find him guilty of murder, he could be found guilty of involuntary manslaughter.
That is going to be the biggest key, I think, in this case, because if the defense were smart, and I'm sure they are, you don't want a lesser included instruction.
How do you fight it?
You fight it by saying, listen, judge, there is one lane here. The prosecution picked one lane, and that lane is this was intentional. So because they picked that lane, you can't now give them an out and let them go into, an involuntary or a voluntary manslaughter lane. They picked this lane. They stuck with it. They're going to get that. The jury's going to get that charge and nothing less. That's how I would argue that. And you don't want the jury to have a choice in this, Jesse, because it was reckless.
It was reckless. Yeah.
So he could be convicted of an involuntary or voluntary manslaughter.
That's what he was initially charged with, was involuntary manslaughter and reckless conduct. And yeah, when I saw that, I said guilty, closed case. But then when they upped it to murder, not so clear cut. Now, I do want to let our viewers know the reason there is a delay. They're working on some housekeeping matters in court. They're talking right now about the jury view of the SUV, the crime scene. It all happened in a car. It's parked in the judge's parking garage. The state is asking that the jurors will be allowed to sit in it. Now, Jonna, this is not the only time that the prosecution really wants the jurors to really feel the evidence, so they want to be able to sit in the car. They also want them to be able to handle the murder weapon. They want them to be, I should say, not even the murder weapon, the gun, the gun.
Right.
Now, what we've heard, the latest, is that the jury might be able to handle the gun in the jury deliberation room. That seems problematic to me.
And I disagree with that ruling, too. And here's why. Nobody, not the prosecution, and I'm sure not the defense, is going to be able to prove whether it was a single action or a double action, right? So they're not going to be able to prove to the jurors how much pressure was needed to pull the trigger at that time. If they were able to prove that, then it makes sense to let the jurors have the gun. They can't. So now the jurors are, what if they conclude that it was double action and it wasn't? Yeah. Not fair. It's bad ruling. Another bad ruling, by the way.
Well, it might be grounds for appeal if he's ultimately convicted.
Oh, sure.
But as we wait for the courtroom feed, I'm looking at it right now. Bruce Harvey, that's the attorney with the long ponytail, for anybody who's been following this case, his trademark ponytail. Again, some housekeeping matters with the court before trial starts. I want to play for you right now the continuation of Danny Jo Carter's testimony. Again, the key witness, Jonna said it best. The key witness, the woman who was in the car. She was driving the car. This is the person you want to listen to. So I'm going to play you some more of her testimony right now. When we come back, hopefully we'll have that live feed in the courtroom. Take a look.
And were you able to tell what he was doing?
No.
And when you looked back in the back seat, where, generally speaking, did you see his hands, the top of the gun, some of the bag, and his hands moving?
Right about there. Right around there. Yeah, because it was real easy. When I turned around, it was very visible.
Okay. And there was a puff of smoke?
Yes.
Okay. Can you tell the jurors how long did it take you to turn around and look after you heard the loud sound?
A second.
Second. And can you tell the jurors, when you turned around and looked, did you see the gun in Mr. McIver's lap?
No, I saw him right there. It may have been 2 seconds. It was quick.
It was quick. Okay.
Well, for a little bit, a second, less than a second, I thought it was a joke. And then I realized it wasn't. And then I knew that I had to get to the nearest emergency room.
What made you realize it wasn't a joke?
I'm not sure. I mean, I just knew that she was really, I'm not sure. I just knew it wasn't a joke.
Okay. So what happened next?
I started blinking my lights and honking my horn to see if I could get the guy that was in front of me to move. And looking for the emergency blinkers, and I asked Tex where the closest emergency room was.
That's Danny Jo Carter, the key witness in the Tex McIver case. We have a live feed right now in that courtroom. There's a bunch of housekeeping going on between the attorneys and the judge. Right now, they're discussing whether or not the jury will have the ability to see the crime scene, to see the SUV where this whole shooting took place. Let's listen in live to, again, that's the defense attorney, Bruce Harvey, speaking with the judge. Let's listen in live. We know you guys like to follow the trial, so why not show you exactly what the conversations are between the attorneys and the judge? This is a real-life courtroom, ladies and gentlemen. These are real-life arguments, and there's real-life people's lives at stake here. So let's talk a little bit about what we just saw with Jonna Spilbor. The judge says he's inclined to allow jurors to see the Tex McIver SUV, but more than likely after the defense expert testifies, not during the prosecution's case. Why would that be?
I think to make it more fair, because if they wait until the defense calls their expert, they will have different issues going on in their minds when they sit inside basically inches away from where Diane died. So I think that's important. I don't even know how important it is for the jurors to sit inside there, but this judge seems to always err on the side of the prosecution. At least that's my feeling at this point. And plus, one of the reasons I don't like it, I don't know exactly how large or small Tex McIver is, but I guarantee you there's not going to be a single juror that is the identical size. We don't precisely know where he was seated, so what is the probative value of that? To have, people of all different heights sitting where we think he was sitting doing what? Doing what? And the vehicle's not going to be in motion when they sit in it. So what exactly is the prosecution gaining from that?
You make a good point. Obviously, every case is different, but how many times do we see cases where the jury is instructed, do not reenact what happened here? You can go to a site visit, but don't fool around. Don't try to do anything that was like the crime itself.
Right.
That's not your job. Your job is to follow the evidence, to follow the testimony, and follow the statements. That's what it is, not create something out of what you think.
Which begs the question, what is it going to prove or disprove to have 12 people, plus alternates, I suppose, sit in the back seat of this SUV or the front seat? Where are they sitting in this SUV? Are they going to be sitting where Diane was seated? Are they going to be sitting where Tex was seated? Where the driver was seated? Or all three? I don't understand the relevance of it, what it stands to prove or disprove. I don't like it.
Well, what I do like is when we were playing the testimony of Danny Jo Carter, it hit me how much of her story helps the defense. So obviously we know that Tex is the shooter, but she testified that Tex said, "Oh, girls, I wish you didn't drive into this part of the neighborhood." He told Diane to give him his gun.
Right.
And she said, you know, so much of what she said backs up his story about it being an accident.
Very much.
But what do you think is really strong to say this was murder?
See, I think Danny Jo Carter was a fabulous witness for the defense. She did not have any agenda. She was very even-keeled. She seemed to have a good memory. The state had to call her, however, because she was the only actual witness to the event. What I find most striking in terms of backing up Tex's story is that, like, if she had testified, he told me to take this shortcut, and the shortcut happened to be in a neighborhood that he thought was dangerous. Yes. Different point of view than if he said, "Oh, girls, you shouldn't have done this. Now hand me my gun." To me, completely consistent with accident.
And you mentioned it before that if someone was going to kill somebody like this, you wouldn't do it in this kind of manner. If you wanted to kill your significant other.
Not that I know how to kill anybody, I don't.
Thank goodness, Jonna. Right. But no, the point is what she also said was, and what so many other witnesses said, nothing remarkable happened in the days, the weeks, the hours, the minutes before all of this happened. It was a normal weekend. They were doing what they normally do, and then this happened.
Right, kind of having fun together.
I know. All right, Jonna, we have a live feed in the courtroom. We're about to hear this next witness come on the stand. The prosecution is still putting on their case, still trying to say that this was an intentional shooting. Let's listen in to this next witness. A lot of back and forth there between the prosecution and the defense about this witness. I'm here with Jonna Spilbor. What's going on here? The defense really doesn't want this witness to testify, if I understand, about all the errors in the Atlanta Police Department investigation. What's going on here, Jonna?
And the defense made a very valid point, which the judge seemed to have agreed with before this testimony began, and that is, it's cumulative. Why are we talking to yet another investigator in this case? And if it's going to be redundant, it should not be allowed. Prosecution got up and basically promised the judge that, look, no, I just have a couple of more key points that really weren't covered before. We're going to get into those, and that's it. As you can see from the number of times the defense attorney had to jump up to object, that is not happening here. And so far, I find this testimony completely cumulative.
It's also problematic in the sense that she's being asked to testify, well, you've driven that neighborhood where the shooting took place. Have you seen a large presence of homeless people? No. You examined the vehicle, and you examined it had a navigation system. A phone had been paired with it. It just seems problematic.
It seems like it should not be allowed. The defense counsel made an excellent point when she starts testifying that in her life, she's not seen homeless people in that particular neighborhood. It doesn't say what was happening on that day, at that time, for whatever reason. She wasn't there. That is very misleading testimony.
All right, everybody, we're back in the courtroom. Let's listen in live.
There was the objection. I believe the question was, did Mr. Rohn cut into a small area of the front seat?
He did, the front passenger seat, yes.
And did it all alter the route or the track of the projectile?
Well, wait. Unless we have some expertise in that.
Yeah, so that one, I'll ask a different question. Did it cut into the bullet hole in the front seat?
It did not.
Okay. And did Mr. Knox, did he do the same examinations that Mr. Rohn did?
He did.
And why did Mr. Knox do that?
Okay, again, Mr. Knox testified, and Mr. Knox can testify about why he did or why he didn't do something. question.
I gather.
I'll ask a different question.
Okay.
Why did the district attorney's office ask Mr. Knox to do examinations that Carl Roan had already done?
Same objection. Same objection.
How is it relevant to what the jury's working through that your office may have had two different people do some work?
I guess it's not.
Okay. The next question.
Well, can we approach Your Honor for a quick second?
Sure.
All right, objection, objection, objection. That's what's going on here. I'm here with criminal defense attorney Jonna Spilbor. Again, you're seeing the back and forth here. Really do not want to get this evidence in because, as you said, it was cumulative. It's already happened. Why do you have this witness? What more can they add? I mean, really, the prosecution was hit pretty hard when the lead detective in this case, there was a lot of holes in his testimony.
Right. But the prosecution knew that going in. And now apparently what it's trying to do is fill in some of those gaps because it brought an investigator from their own office to try to testify to that. But I don't see her really doing that. In fact, I see her trying to give testimony that rightfully so the defense counsel is objecting to, like we touched on a second ago. We don't care what her opinion is about how many homeless people are in that neighborhood.
But the prosecution's still trying to get it in, and we do have a live feed back in the courtroom. So let's try and see what the prosecution is trying to do. Let's listen in live. Frustration is mounting in that courtroom, mostly on the defense side, about what is being asked for this witness. But unfortunately, I have to sign off my guest for this morning, Jonna Spilbor. Jonna, it was great to see you.
Always a pleasure.
Before I let you go, final thoughts as the prosecution ends their case this week. What more do they need to do? Because as we keep saying, they haven't done everything that they need to yet.
And my prediction is they won't be able to. And we can expect a motion to dismiss at the close of the prosecution's case. It probably will fail, but that's a sort of pro forma thing that the defense needs to do. And I am dying to know whether Tex McIver is going to take the stand in this case.
Guess what?
What?
We all are dying to know. And that's what we'll do. We'll wait and see.
Right.
Jonna,
will you have me back if he does?
You don't even have to ask.
Oh,
of
good.
course. Minute-by-minute analysis with Jonna Spilbor. Thank you so much for coming
Thank
in.
you.
All right, everybody, let's go back into the courtroom and see what's happening next in the Tex McIver case out of Atlanta.